is a private legal practitioner, lawyer Richard Niema. Thanks for joining us and welcome to Newsnight.
Thank you, Mr. Speaker.
I would want you to listen with me, listen to a report filed by my colleague Philip Abutiate, explaining what really happened for the young man in question to be picked up and sent to the law court, and whether or not he pleaded guilty before he was sentenced. Let's listen to that report filed by Philip Abutiate. Then I'm sure we can expand the conversation from there.
Afol, popularly known on social media as Kwame Nkrumah II, appeared before an Accra Circuit Court where he pleaded guilty to charges of threats of death and offensive conduct conducive to the breach of peace. He pleaded with the government officials to forgive him for his behavior. The Ghana Police Service arrested Afol for issuing death threats and inciting violence during a TikTok live stream. He was picked up at his hideout near Kaswa Market at around 2:20 p.m. on Saturday, September 13. In the video, Afol allegedly threatened to kill government officials, journalists and civil servants using official green number plates. He was also reported to have threatened to burn marketplaces and encourage others to carry out similar acts. Following his arrests, the police stressed that while it upholds freedom of speech, it will not tolerate statements that incite violence, insecurity, or public disorder.
Sure, you heard that report filed by Philip Abutiate. Now, the question is, he was picked up on Saturday, and as of today, he's been jailed. Was it as a result of the fact that he went pleading guilty?
Yes, that is correct. The way our criminal justice system works, if you go to court and you plead guilty, there is no further proceedings. On that same day, you are going to get your sentence. And so I believe that is why the judgment has come so fast like this.
Now, under the Ghanaian law, what really constitutes threat of death? I mean,
well, if you look at Section 75 of the Criminal and Other Offences Act, 1960, Act 29, permit me to read what it actually says. It says that a person who threatens any other person with death with intent to put that person in fear of death commits a second-degree felony. And so, threat of death simply means that you are publishing information that shows that you want to put somebody's life to an end. And whilst publishing that information, you have the intention of putting the fear of death in that person. Now, this gentleman, we are told, said on TikTok that he's going to kill anybody who sits in the vehicle with green number plates. We all know who are the people who sit in the green number plates in Ghana here.
yeah.
And he said to have also said that he will kill journalists who defend those people. And he was actually encouraging his followers to also do the same. These are matters that can lead to civil unrest in other countries. You remember in 1992, thereabout, it was a radio commentary that led to the Rwandan genocide.
Yeah, kill
that
the
we are
cockroaches.
talking about a lot.
Yeah, kill the cockroaches statement.
Exactly. And so I believe that the statements this gentleman made were bad enough. And I think he's been lucky that the judge gave him only 7 months. Because actually, the law says that it is a second-degree felony. And if you look at Section 296 of Act 30, for a second-degree felony, you can get up to a maximum of 10 years. So if the judge decided to give him 7 years, then it means he's been very, very fortunate. And the judge has been very, very lenient with him.
Is it just by word of mouth that then you can be charged and get prosecuted, or the investigative body, in this case the police, would have to find out whether you are in that capacity to carry out your threat?
Okay, all of that would have come out if the case traveled to trial. Okay, but once he himself did not want to go to trial and he simply went and said, I am guilty, all those things do not matter again because he has accepted that he has committed the offense. But if he went and said he was not guilty and the matter went through trial, that was when the prosecution will now have the burden of proving that the man actually meant harm and he was in a position to harm and he could actually execute the harm. But so long as there was no trial and he himself has accepted that he's guilty, all those things will not come up.
Quite intrigued with what you have just said. But we've had instances where the accuser has been asked to, when you go, just say you are guilty. And I'm sure you know of that, where some prosecutors would, one way or the other, want to make their work so easy. But in the end, they want to tell you that when you say you are guilty, then the trial judge can be very lenient on you. Do you think that may have been possible? Because I am really wondering why he'll just go and say and plead guilty to that offense.
Well, if you are guilty, you are guilty. The point is that, yes, what you are saying, I can attest to it. Because there are several instances where persons have been, advised by prosecution, especially the police officers, to simply go and plead guilty and be free. And then the persons have regretted later on. So, yes, it is something that actually happens. As to whether that is what happened in this case or not, we do not have the evidence, so we can't verify. But the general advice I'll give to people who are accused of crime is that when you are going to court, be sure you consult a legal practitioner to advise you on what your rights are and what are not your rights. Because once you go to court and you tell the judge that I am guilty, the judge cannot save you. All what the judge can do is to convict you. I remember sometime, I think about 2 or 3 weeks ago, there was a young guy, I think he was 18 years actually, who had been accused of robbery at the Shaman Circuit Court. The reason why he had been accused was that he tried to snatch a woman's phone from her. The woman fought with him. The two of them fell into a gutter, and then the gentleman was arrested and given to the police. Now, because he attempted to take the phone, he's been charged with robbery. Robbery to the minimum sentence you can get is 10 years. So as soon as this gentleman came to court, they read the charges to him and the judge said, hey, are you guilty or not? He said, I'm guilty. The judge asked him 3 times, are you sure you are guilty? Please read and explain to him again. Let him be sure of what he's saying. 3 times, the gentleman said he was guilty. The judge had no option than to sentence him to 10 years imprisonment. Now you could see the reaction of the guy. He almost wanted to attack the judge in court. It was so clear that somebody had told him that if he comes and plead guilty, he'll get a lower sentence. But obviously, because he didn't have advice, he went and pleaded guilty, and that happened to him. And so those things, they do happen. But as we speak now, we don't have the evidence to know whether this is what happened to the gentleman.
What is the motivation for that?
The prosecution will always want to finish the case and move on to another case because you and I are aware that crime happens on a daily basis. Sometimes you go to the police station and the case log over there, I think it is not easy for them. Even the courts themselves, the courts too are suffering with too many cases coming up and down. So if you come and plead guilty and then you are going to be sentenced for the police and the court to be free, I think they'll be happy to sentence you so that they'll be free to move on to another case.
Do you know of any KPI requirements as far as a prosecutor is able to ensure that there is an expeditious trial that happened? I mean, that prosecutor really gets some bonus of or whatsoever. I'm asking this not based on the fact that you have been a police officer and a prosecutor, but because of your proximity to the various courts.
Well, as a matter of fact, I cannot confirm whether there is any such KPI for the prosecutors. But what I can confirm to you is that when they come out of court and they were able to jail the people and they go and sit down for lunch, they brag about the number of people they've been able to jail. So maybe that is a KPI. On
Really?
the other side, on the other side, for the judges, I can speak for them because their promotion also depends on the number of cases they were able to finish within a year. And so no judge wants cases that are dragging, going and coming here and there because it affects their promotion. And so they also want to do everything possible to ensure that any case that comes to their table, they are able to deal with it expeditiously and move on to the next one.
Council, this is serious.
Oh, Mr. Speaker, if you like, go to some of the places that some of our policemen who are prosecutors go for lunch and try and listen to their conversations, and you will testify to what I'm talking about.
And that they brag over the fact that they have been able to, ensure somebody is jailed.
Of course, because it is their duty to ensure that the bad guys are not on the street and they are put in prison. And just as we lawyers prepare in the night, we read to come and defend the accused persons, they also prepare to ensure that when they come, they are able to win the case. So when they go and they don't win, they become sad. When they go and they win, they become very happy. And some of them, when they are sitting at the restaurants, having conversations among themselves, they actually talk about the fact that yes, that guy, I was able to get him inside. They say it all the time.
No, but counsel, in the case of that young man at around Ashaiman, then I would ask a question: what really constitutes robbery?
Well, robbery, according to the law, is that you have used force to deprive someone of his personal property. Okay, and so if, for example, I come to your office, you go out of the office, by the time you come back, money that was on your table is not there, and I'm arrested to have stolen it, I'll be facing stealing because I did not force you to take the money. But if I entered the office, the money was in front of you, I forced you, I tie you up, I strangle you, and I take the money from your hands and go away, it becomes robbery. So there's a thin line between stealing and robbery. As soon as you apply force to deprive the person of his property, it becomes robbery. But if you don't apply force, it doesn't matter enough to take away the thing, it is stealing.
It doesn't matter whether I only struggled with you or I had to point a gun at you or maybe any other weapon.
Whether it was a gun, whether it was my physical hand, whether it was a pen, whether it was a small knife or a stone, so long as I use force and threats to be able to take it out of you, it becomes robbery. So it graduates from stealing to robbery. And when it comes to robbery, the minimum sentence is 10 years. As for stealing, there's no minimum sentence. So sometimes, if you are lucky, you can get 6 months, 1 year, and go and come, even though there's a maximum penalty of about 25 years.
And so in the case of this young man, if he had pleaded not guilty, he may have traveled for some time, but he will still be facing robbery charges.
You see, there are so many advantages in pleading not guilty. It is possible that if he had not pleaded guilty and maybe the court had granted him bail, he could have gone back to plead with the woman, beg the woman, and then the woman would decide to forgive her and withdraw the case out of court. And he will not even go to jail at all. Okay? But once you go and on the first day you plead guilty, you lose all that opportunity. Okay, so the moment you plead guilty, your chances are finished. But if you plead not guilty, the case can travel throughout the time that the case is traveling. You can exercise a lot of options. And I've mentioned one of them. You can go to the complainant and even refund the money that you stole from him, or even multiply the money by 2 and plead with him or her that they should allow the case to be taken out of court. And you could be lucky.
Now, Counsel, back to the young man in question's case, he was sentenced to 7 months. Is it proportionate compared to similar offences?
Like I've said, I think he's been very fortunate because a threat of death is not a small offense. It is a second degree felony. And in Ghana, second degree felony carries up to a maximum of 10 years. And so, even if the judge gave him 9 years, the judge was within range. Or even if the judge had given him 10 years, the judge was within range. So he was very fortunate. And sometimes, of course, the prosecutors are also right sometimes. When you go and you don't stress the court and you just go and admit, the court will give you a lenient sentence, hoping that you go and reform and not come back to commit the same offense again. And I believe that is what happened here. That is why he probably got the 7 months.
Well, what lesson does this serve us as far as social media conversation is concerned and the law, or coupled with the law?
Mr. Speaker, in fact, I wish that the whole Ghana was listening to our interview right now, so that people will know that if you go and sit on radio, TV, Facebook, TikTok, YouTube, or wherever, and you go and issue threats of death to people, there are consequences. And the consequences are that you can go to jail up to 10 years. I wish the young people were listening to this interview so that they would desist from doing that, because we are beginning to have a culture where everyone thinks once I can get a phone and have some data and live stream, I can say whatever I want. In fact, you can say whatever you want, but the consequences are there, as this guy has been jailed today and we are talking about it.
Counsel, most grateful for your time on News Night this evening.
Thank you very much, Mr. Speaker.
So I've been speaking with lawyer Richard Niama. He is a private legal practitioner. We should